Let's go.
Só avisar quando a gente estiver online. Já estamos online. Bom, bom dia a todos no Brasil. Good morning, everyone here in Brazil, and good morning, everyone in Singapore, and good night, actually, everyone in Singapore and in Asia that is watching us. And today we have a really important event because we're talking about the Singapore Convention that Brazil has not signed yet, and of course has not ratified the convention, but it's really important internationally and really important for our country, for the business in our country, of course. And we have four actually keynote speakers here, five actually keynote speakers, and important that they made two of them from Singapore that made the Singapore Convention. But first, on a first hand, I would like to thank you for your presence and for accepting the invitation on behalf of our president of the Brazilian Center for Arbitration and Mediation, Dr. Gustavo Schmidt. And after this crisis, this coronavirus crisis here in Brazil, Gustavo Schmidt decided that we should act in two fronts, mainly producing knowledge, and that's why the webinars, and this is our first international webinar. So we're gonna have some more international webinars, but this is the first one, so it's a great preview actually. And the other front is the solidarity front. Almost 1 million reais to donate to the Rio de Janeiro public hospitals. So we're donating hand sanitizers and face shields for the doctors that they don't have it, doctors, nurses, and so and they really appreciate it because in this moment this is really bankrupt, I can say that, and all the help is appreciated. So producing knowledge in this pandemic days and solidarity, I think that's the way to go, and CBMA has got the front on it. So let's start presenting the speakers now. First, of course, I would like to start with the ladies, as always, and I'll introduce you Gloria Lin. She's the director of the Legal Industry Division of the Ministry of Law, Singapore. Her division sees the policies for development of Singapore legal service sectors include dispute resolution and the implementation of the Singapore Convention on Mediation. She's concurrently Registrar of the Legal Service Regulatory Authority. Gloria was actively involved in the overall planning and execution of the signing of the Singapore Convention on Mediation in August 2019, in her capacity as Deputy Chair of the SCM Organizing Committee and Chair of the Singapore Convention Week and Conference Subcommittee. So Gloria actively acted in the ratification and in the implementation of the Singapore Convention, and I congratulate you for that, Gloria. Michele Lyra da Cunha Costa. She's a Senior Legal Counsel Litigation Latin American and Caribbean for Shell, currently responsible for handling Shell's high-risk disputes in Latin America and the Caribbean region. Brazilian lawyer with 20 years of experience in litigation in private practice, and as in-house, whose practices focus on preventing litigation and on dispute resolution of complex cases, and on legal advice related to several regulated sectors. She has an LL.M. from FRJ 2009, and the program on negotiation and leadership from Harvard Law School in 2014. Now, let's go, of course, to the guys, and I congratulate you, Michele, for all your background here in dispute resolution. It's really important to have you here today represent this sector, the private sector. George Lin, also from Singapore, is a senior counsel and chairman of the Singapore International Mediation Centre. He's a past president of the Law Society of Singapore and serves on the SIAC International Arbitration Panel. In 2014, George co-chaired a working group to develop Singapore as an international mediation center. He was Singapore's mediation consultant to UNCITRAL Working Group 2, which led to the signing of the Singapore Convention on Mediation on August 7th of 2019. So as you guys can see, as the Brazilians that are watching can see, both George and Gloria acted in the, they crafted the Singapore Convention. So it's really important to have them here today. And Jair Gevaerd is an international cross-cultural ADR practitioner, specialist, Idea Law, Roma, Italy, Master and Doctor of Laws, da Universidade Federal do Paraná, LL.M. Resolution, Arbitration, Pepperdine University, Strauss Institute Ambassador for Brazil, PUC, Pontifical Catholic University of Paraná, Professor of Law, the International Cross-Culture, and that's it. I think that's enough. A lawyer, arbitrator, mediator, and and a lot more. Last but not least, Paul Eric Mason is an international legal counsel, mediator, and arbitrator based in Miami and Rio. Paul speaks Portuguese, and he's American, but he speaks Portuguese and English, of course. Mr. Mason was the first mediator certified in Brazil by the IMI. He's on the list of CBMA, mediators and arbitrators, and has successfully mediated a wide range of commercial and other disputes in both English and Portuguese for the ICC, ICDR, US courts, and other organizations with parties from Asia, Europe, Latin America, including Brazil and North America. He participated as a delegate at the Singapore Convention, signing and related events in Singapore in August 2019. He also helped arrange and took part in the world's first successful international mediation by video conference in 2006 as counsel for the Brazilian side in a dispute with a large US multinational company. So Paul, it was one of the practitioners that act in the Singapore, that was there in Singapore in August 2019. So you watched this historical moment, right, Paul? So thanks a lot for everyone for being here. And with no further ado, I would like to give the stage to my friend Jair. Thank you.
Thanks, Daniel. It was a great introduction. Having a lot of titles and a long short bio means nothing, but that some of us, fortunately not the ladies especially, but some of us are old enough, so we've been doing a lot of things, right? George, of course, is younger than myself, and Paul even younger than all of us here. But just the thing is, because what counts after a stage is, I mean, I like to think like this, is what you have inside. But anyways, thanks, Daniel. Good morning to you all. I mean, our friends from the audience. I know that nowadays there are a lot of webinars popping up, and so you have to choose very wisely which ones watch or not. All of them are good quality webinars and everything, but just the same, it's a wonderful privilege to have your attention this morning in Brazil, this evening in Brazil and in the US, and this evening in Singapore. And I would like you to know that this is not about the wonderfully qualified people that are here right now, but this is about yourselves. And in this, on this, I would like to just bring up a note on the efforts that CBMA is actually doing to during this pandemic, which is not being easy for none of us. They are building knowledge through this kind of webinars, right? So most of the ADR providers in the world, they do a very good job on hosting and facilitating procedural cases like arbitration and mediation and so on. CBMA is not only one of the most important providers in Brazil, but it is also going way beyond what would be, originally its obligation. It is being active as a member of the ADR ecosystem. I like to think that exactly as it happens with the environment the species, the legal species, I mean, let's say the lawyers, the mediators, the litigators, the arbitrators would not thrive or exist without a competent ecosystem that would provide them the good ground for them to do their job, right? So in CBMA, through our friend and he's really doing a great job for the ADR in Brazil, Gustavo Schmidt. You are doing this, Daniel. So I would like to congratulate yourselves, and also I would like to say that this is I mean quintessential for we have a good development of our system in Brazil, right? So especially after being long enough in this planet and supposedly had collected some titles and qualifications, one has at least to be sensible enough and know better and understand when the time to rest and listen comes. And this is exactly where I am now, right? So we have wonderfully qualified people here. The Singapore Convention, as I see it, is one of the most important legal documents of our times. It hasn't yet blossomed as it will in time. So if we take into consideration that the 58 New York Convention took 30 and something years to be enacted, to become a law in Brazil, to be ratified in Brazil, right? So we do have a long time span to go through. But so Singapore Convention is really important. This webinar will bring to you, my dear friends from the audience, in first-hand information on how the convention was actually built from the scratch by this very hands that are here today. So you have George, you have Gloria, you have Paul. The three of them went there. We do have Michele, which despite her age, she's very young still, but she has been for almost 20 years or even more than 20 years in the forefront of the business battle, litigating cases. She's responsible for Latin America and the Caribbean when it comes to the interest of a great player in the oil and gas industry. So we do have 4 people that will that can witness the importance of the Singapore Convention on one hand, and that can tell you firsthand with hands on the field how important it might be for the thriving of the business. Desperately need to make this world go on again and escape from this recession that we are getting into. So my only concern here, so I will rest my case, I will listen alongside with the audience. Maybe I'll bring up some questions as a moderator, and I just brought this very simple, and let me just try to do this in the proper way. Very simple set of slides. Are you seeing this, Daniel? Can you give me some? Can you back? Okay, perfect. So fine, good. So the idea here, this is. I'm sorry. This is our webinar. So thanks to CBMA and so on. And Gloria will begin, and she will talk about what is the Singapore Convention, so the very fundamentals and the basic things about the Singapore Convention, what it is and what it does, why mediation, the advantages of it, the summary of the convention's key features, the key milestones since December 2018, when the United Nations General Assembly adopted the Singapore Convention, and she will then go to the conclusions. She will wrap up with the need, talking about the need for for the adoption by countries. So there's a huge campaign on the signing and ratifying of this convention, adoption by business, and strong institutions and qualified practitioners. George will come on the segue, talking about his experience, very unique, very valuable experience as a delegate participating in the work group 2 of the convention. So he went through, along many other delegates, on important key deliberations that end up making the meat that we have in the convention itself. Then he will talk about the key challenges when they were negotiating the convention text. It was not easy. So this specific part has a historical importance for those that are interested in the international mediation setting. And he will also talk to us about the experience of the Singapore International Mediation Centre on dealing with international commercial mediation after the Singapore Convention was enforced through ratification in Singapore. So Singapore is, if I'm not wrong, the first or one of the first countries to not only sign but ratify the convention. He will bring all the details on that. Then we will have the privilege of listening to Sir Paul Mason. He will talk about many important aspects of the convention, how it does not affect the mediation process itself, except for requiring a very minimum ethical standards and so on and so forth. The greater flexibility of Singapore Convention on Mediation, if compared with the 58 New York Convention on Arbitration, this is this aspect for sure is being very much studied in universities and so on and so forth. So you will get this information firsthand here. The possible implementation route in Brazil. Why? Because, well, it is not that easy. We will need in Brazil to go through many different considerations on the features of the law, the act that will bring up, that will enact the convention in Brazil. And he will talk also the reservations which were available and so on, and challenges and the proactive benefits of the convention. Right. So after that, we will have Michele Lyra talking about the benefits of the Singapore Convention for International Business. Since she is working with this every day, she is right into the trench of daily international business in a very sensitive industry, which is oil and gas. She works for Shell. So what she can bring up here is very, very important. And she will talk also about the case of Brazil on the oil and gas industry and give us a practical perspective. So after taking more time than I actually wanted to, let me just, since the stage is already set up, let me just ask for Gloria to come up and bring up her very important speech here. Thanks, my friends.
Thanks so much, Jair, and
you're very welcome.
Thank you. And it's really a pleasure to be here. I'm Gloria Lim, and I'm the director of the Legal Industry Division from the Singapore Ministry of Law. And a real pleasure to be here participating in today's webinar organized by CBMA. To start off discussions, I thought I would go into what is the Singapore Convention on Mediation, and perhaps if I could ask Daniel to perhaps help me put out my first slide. So the Singapore Convention on Mediation is essentially an international framework for the enforcement of commercial settlement agreements resulting from mediation. And what this convention does is that it ensures that such settlements are binding and enforceable in accordance with a streamlined procedure. And this provides businesses with mediation as an additional avenue other than existing options such as litigation and arbitration to resolve their cross-border commercial disputes. But I think before we even discuss the details of the convention, perhaps we should answer the more basic question. So why mediation? And looking at this slide, I've listed some of the traits of mediation. Several years ago in Singapore, we undertook a review of our own international commercial mediation framework. And we introduced various measures to strengthen it. And there are many reasons why we see as an international business hub, we see mediation as important. Mediation has many advantages. Firstly, it supports party autonomy. As we all know, the mediator's role is not as a judge. His role is not to adjudicate, but rather to be facilitative of discussion so that the disputing parties can themselves arrive at a mutually acceptable solution. And in this way, the parties retain full control over the outcome. We see mediation as a process that allows for very flexible solutioning. So the solutions worked out can be legal, sometimes they can be non-legal in nature or a combination of different creative solutions. The parties have full flexibility to shape the way that the disputes are resolved. Mediation is also known to be time and cost effective. So unlike more traditional process-driven processes like litigation or arbitration, which could span from months to years, mediation is often a shorter process. Sometimes it can take as short as one day, 2 days. And this means a successful mediation can result in significant time and cost savings for the parties involved. And it is also known to be very effective once the parties are willing to come to the table to mediate. So based on statistics we have from the Singapore International Mediation Centre, which George chairs, mediation success rates can go as high as 75 to 80%. So the chances of coming to settlement are quite high once the parties are willing to come to the table. We also appreciate that mediation is non-adversarial. It preserves harmony and relationships and is useful in contexts where the parties have ongoing dealings and they need to preserve that commercial or business relationship. And lastly, it's private and confidential. So typically the mediation process is confidential, it's held behind closed doors, and unlike court proceedings, which are public. But until the introduction of the Singapore Convention, a key challenge to the use of mediation was that there was no international framework for enforcement of mediated settlement agreements. What this means then would be that a settlement agreement made in one country only has contractual force, and therefore when a party seeks to enforce a mediated settlement agreement somewhere else in another country or multiple countries, they will then have to commence separate legal proceedings in each country. And this could potentially be costly for the parties and time consuming. So it was in response to this need that the Singapore Convention was developed and adopted by the United Nations. So I turn now to the next slide, which shows some of the key features of the Singapore Convention. So the primary goals of this convention are to facilitate international trade and to promote the use of mediation for the resolution of cross-border commercial disputes. And the convention essentially applies to an international settlement agreement, which is commercial in nature and which is concluded in writing. So it does not apply to settlement agreements that are enforceable as a judgment or as an arbitral award. It also does not apply to settlement agreements that are concluded for personal, family, household purposes, or agreements relating to family inheritance or employment law. So what the convention sets out is that it sets out what a disputant relying on the settlement agreement must apply to the competent authority of the signatory state. That's usually the courts in order to enforce such an agreement. And it allows a signatory state the flexibility to enact their own rules of procedure for enforcement and invocation under the convention. And this is really important, taking into consideration the many existing domestic laws, frameworks, and procedures that this convention needs to cater to. So under the convention, a signatory state will have to enforce a settlement agreement in accordance with its own rules of procedure under the conditions laid down in the convention, and likewise allow a party, if needed, to invoke the settlement agreement to prove that the matter has already been resolved. And there are only certain limited grounds under which relief under the convention may be refused. It's somewhat similar in its structure to the New York Convention. For example, if granting relief would be contrary to the terms of the settlement agreement, or if granting relief would be contrary to public policy of the signatory state. So there are other details in the convention, and I think Paul will go on to share about the reservations that the convention allows parties to declare. But in sum, this convention gives commercial parties assurance and certainty that their cross-border mediated settlement agreements will be enforceable. I have not covered all the details in my presentation, but I thought it would be useful to point participants at today's webinar to a useful resource. And I turn now to the next slide. The next slide shows that we have set up a website. It consolidates information on the convention, and it's a source of information you can tap on. It's at www.singaporeconvention.org. And within the website, you will find links to the relevant convention text. You will also have links to the model law that was developed alongside the convention and other related materials on the discussions surrounding the convention. So I move on to the next slide, which is key milestones and developments. And the pace of developments for this convention have been really encouraging. And to share some of the key milestones, the UNCITRAL Working Group 2 that you see in the picture started work in 2015 with a mandate to consider the issue of enforcement of international mediated settlement agreements. And in fact, actually, this was not an easy area, because more than a decade ago, in 2002, they had actually already discussed this, but the discussions did not advance. But in 2015, a new mandate was given to the Commission, by the Commission to the working group, and it was really felt that the time was ripe for a fresh attempt. And this was because there was growing recognition by member states and the Commission that mediation was increasingly being used as a cross-border dispute resolution option. And there were also calls by international businesses for a more expedited cross-border enforcement of mediated settlement agreements. So on Singapore's part, we fully supported this effort, and we participated actively, and a Singaporean chaired the working group deliberations. And George, who is here with us today, was a delegate at the working group. So I will leave George to share about his experience working on this. But it took the working group around 3 years to work on the convention. And in February 2018, the working group finalized the text of the convention, and also they worked alongside with that a model law. And by December 2018, the UN General Assembly adopted the convention. And they also authorized the signing of the convention to be held in Singapore, and also for the convention to be known as the Singapore Convention on Mediation. So I move on to the next slide. You can see from this picture, the international support for the Singapore Convention has been very encouraging. So on the 7th of August last year, the day the convention opened for signature in Singapore, 46 countries signed it. And this is, in fact, one of the highest number of first-day signatories for any United Nations Trade Convention. And it really reflects a recognition by the international community of the benefits that the convention will bring. And amongst the signatories were two of the largest economies in the world, the United States and China. We had also large 3 out of the 4 largest economies in Asia. Apart from China, there was India and South Korea, and half of the ASEAN countries, Brunei, Laos, Malaysia, Philippines, Singapore signed. Since that ceremony, 6 more countries have signed, bringing the total number of signatories to 52. In order for the convention to enter into force, at least 3 signatory countries must deposit their instrument of ratification, and the convention then comes into force 6 months after the 3rd state deposits its instrument. So I'm very pleased to share that this requirement has been met. And in February this year, Singapore and Fiji deposited our respective instruments of ratification. And in March, Qatar deposited the 3rd instrument of ratification. So the convention will enter into force on the 12th of September this year. And since then, a further country, Saudi Arabia, has ratified in May, and we are optimistic that there will be more to come. Now, the convention's entry into force this year is really timely. As Jair and Daniel have mentioned, COVID-19 has spread globally. It has had a significant impact on businesses and commercial dispute resolution, and many businesses all over the world are facing increasing challenges, uncertainty, and affected by disruption to supply chains, workplace operations, and business pipelines. And in the short term, it is foreseeable that there will be an increase in the number of parties finding themselves unable to comply with existing contractual obligations, and it may result in a spike in commercial disputes. So mediation is particularly useful and relevant during this period. Many companies which are in financial difficulty or facing cash flow issues may not have the capacity to engage in protracted or expensive legal proceedings. And as mentioned earlier, mediation provides a viable and cost and time-effective option. And even if mediation does not lead to final settlement, it is flexible. It could help the parties to lay out and resolve some issues first, so that the tribunal or court can decide on the key outstanding issues. So this also leads to greater efficiency in the conduct of arbitral or court proceedings as well, and time and cost savings for all. So I turn now to the last slide. We anticipate that more businesses will avail themselves of the benefits that the mediation process provides, and as adoption of the convention becomes more prevalent globally. But for us to reap the full benefits of the convention, a few key elements need to be in place. So firstly, adoption by countries. For mediated settlement agreements to be efficiently enforced internationally, there needs to be a critical mass of countries that sign on to the convention. Currently, there are 52 signatories and 4 countries have ratified, but we want to continue to encourage more countries to sign and ratify. And on our part, Singapore has ratified, and we're implementing our domestic legislation to give effect to the convention. We are also happy to share our experience and provide technical assistance when needed to assist countries looking to sign or ratify the convention. Secondly, it needs to be adopted by businesses. So for businesses to benefit from the convention, they would need to be familiar with the use of mediation and be willing to use it as a tool to resolve commercial disputes. And thirdly, we need strong institutions, like CBMA and other mediation institutions, and qualified practitioners to support the increasing adoption of mediation. Institutions need to be built up, institutions that are capable of delivering high quality professional and a strong pool of practitioners who understand it and who can build the international commercial mediation space and advise parties on its use and when it is appropriate to use mediation. So this requires a concerted effort of the legal and dispute resolution community. So we look forward to working with other countries, practitioners and businesses to support the growth of mediation and the adoption of the Convention on Mediation. So I hand the time back to Jair for the next speaker.
Thanks, Gloria. It was just very enlightening. And have you been teaching before? Are you a professor too? Because you're very good. You're very good. You're just explain everything in a spectacular way. So congratulations on that. So you gave to our audience a very sharp and precise view of what the convention is. We will have a lot more coming. And just let me ask you something, Gloria. What exactly you do inside this institution, which is the Singapore, it's represented by a site and everything. What is exactly your role on promoting, the adoption of the convention by the countries and by businesses? What kind of initiatives are being carried on so far on this?
Yeah, so we, of course, participate actively in the promotion of the convention. We work closely with the legal and the dispute resolution community to create more awareness about the convention. And we do so because we see the importance of mediation as something that businesses will appreciate. And I think part of it is the awareness needs to be a lot more as to how parties can leverage on mediation as a means of resolving problems. Essentially, it is a flexible means. And so we work on that. We work together with the dispute resolution institutions, both local within Singapore and also international, to create that awareness. And then, of course, in Singapore, we are also working on our own implementation of the convention. So if countries are interested in sharing experiences with us and finding out how we have gone about doing it, we'd be very happy to share our experience. Of course, every country is different, but we have a means. We have done our own act, we've done a bill, and if that could be useful to other countries, we're very happy to share our thinking behind that.
Thank you, Gloria. So this is for the audience. Basically, you will be free after the end of the four speeches to bring up questions. I'm sure that not only Gloria, but George and all the others distinguished speakers here will be more than happy to respond to that. So if you have, my dear friends, on the audience, any question, that please just jot it down, save it for later, or send it through our chat, and we'll be more than happy to ask it later. I'm sorry. So George, this is your turn, my friend. Thanks, Gloria, again. So the stage is all yours, my friend. Please bring just let us enjoy your experience, because you've been there doing a lot of the real work. Go ahead, my friend. Thanks for being here.
Thank you, Jair. Bonjour. And thank you, CBMA, for organizing this webinar and inviting Gloria and myself to be a part of this. It's a real privilege. I must confess this. Okay, I have an affinity for Brazil. I told Jair and Paul and Daniel this, that for some reason, when I grew up, I was interested in bossa nova music. So Desafinado, Girl from Ipanema, they are in my record books, okay? And I still listen to those songs today. And my son and I follow Liverpool Football Club. And you've got two Brazilians there, right? Roberto Firmino and Fabinho.
Yeah.
And you Brazilians are fantastic. So I want to thank Brazilians. I know you're going through a tough time, but you get through this. But thank you for what you've given to the world.
But George, we don't like Liverpool now because they beat Flamengo in the final of the World Series. So it's not a good time to talk about Liverpool, especially for real. I'm kidding, of course.
Okay, we will need a mediator for that, Daniel. All right. So on that note, I'm going to share my experience as a delegate at UNCITRAL Working Group 2. But really to share 3 points today, and Jair alluded to that. I think firstly, the impact of the convention on the growth of mediation. Secondly, the rising trend to use hybrid processes, hybrid ADR processes. And the third point for me, which is important for young lawyers, young arbitrators and mediators, what I call the changing role of the lawyer. But before I get into UNCITRAL and the convention, many people have asked me this question: what is the need for the convention? Okay, so I've been mediating for 23 years now, and I think for those of you who are mediators, you know this. If you structure a mediated settlement properly, and ensure that the parties know what they're going into and they can implement the terms, enforceability is usually not a problem. Maybe in a small fraction of cases, if something goes wrong later, then you have an issue. But generally speaking, it is not a big problem. But the problem is this: when you go to parties or clients or companies, and I think Michele will attest to this, and you ask them, would you attempt mediation? And then they'll ask you, okay, if we have a settlement, can I enforce it? And it's a fair question, right? I mean, if you are a party to a contract, you want it to be enforceable. And you tell parties, no, you can't enforce it. A cross-border dispute, you can't enforce it. They won't come to the table to mediate. So that's the problem we face. So apart from the issue of enforceability, which is important, this convention gives teeth to mediation, and it brings parties to the table. So that for us is very important. So I for one was very happy when I heard that UNCITRAL was convening a working group 2 to look into to explore the setting up of a convention on mediation. Gloria told you that was in 2015. So I was part of that process, and I'll just show you a photo in the next slide. Daniel, you could just show that. Okay, so this is working group 2 on dispute settlement. This is the inside of the UN building, and you can see some photos of there. We had 50 countries, 50 states who attended the sessions. There were sessions running over 3 years in New York and Vienna. Each session, each time would be like 5 full days. You have people talking whole day, 6 languages. For me, it was a fantastic experience. It was amazing. It was the icing on the cake. I will confess to you that it was not so easy because, you're sitting down the whole day and listening to people. It's not the easiest thing to do. But it was really interesting. And I called it a giant mediation because you have people with different interests, political, legal, social, and they wouldn't tell you their interests, it's like in a mediation. You have to slowly listen carefully and find out what the interests were. And people will say something and they'll wait for another state to say that. And if the states are aligned, you find out that messages come through. So it was tough going, I'll tell you that, because representatives of the states came from different backgrounds, civil jurisdiction, common law jurisdiction. It was just so different. But it was, as I told you, it was a fantastic experience. And in mediations, we use the term private sessions. So while you have the big joint session, a lot of the decisions or the negotiations took place behind the scenes, okay? Where people were having dinners or lunches and we were having groups talking. But, it was fantastic because after 3 years, we came up with that document, and Gloria showed you that photo. Can I just show you the next slide, please? Yeah. So the session that Singapore was asked to chair, was elected to chair. That lady in the center there is Natalie Morris Sharma from the Ministry of Law, is Gloria's colleague, and Sharon Ong, also Ministry of Law. So the 3 of us represented Singapore, and it was an exciting exciting time for us. So when we cobbled the document together, it was such a relief. That was February 2018. But I think if you ask Gloria then, okay, hey, how many states do you think would sign on opening day? Gloria, if I told you 10, you would have been very happy, right? Yes, I would have been very happy if you told me 10. But you know, 46 countries signed. And can I have the next slide, please? And the significance of this, okay, and I will show you from this slide. So this is a list of the countries who signed. On 7th of August, which is the first day, we had India, US, China. Okay, that to me is significant. Okay, so apart from the fact that we have 46 countries, 3 of those countries make up more than half of the world's population. Okay, and I know that the US and China are Brazil's big trading partners. Okay, and South Korea too. So it was really, really wonderful to have this, but it also showed that people underestimated the value of this convention. Okay, but when the numbers started coming in, we knew that genuinely there was an interest in mediation all around the world. So 46 countries signed on the 7th of August, 6 more have signed since then. So we have 52 countries now. And then in May, Saudi Arabia, well, 4 countries ratified, as Gloria told you, then Saudi Arabia was the 4th one. And Belarus, okay, has gone on record to say that it will be ratifying soon. So we'll probably have the 5th one very soon. So for me, this was the big significance. Okay, and I suppose you will ask me, what is the value of the convention? What does it translate to? And if I could have the first slide, the next slide. Yeah. You know, I chair the Singapore International Mediation Centre. We are a new body, we're like 5 years old, okay? And we are non-profit, but our goal is to promote the mediation of cross-border disputes in Asia and around the world, okay? So 5 years ago, we will be knocking on doors in China, India, Korea, Japan. And I'll tell people, ask you, you know, what's mediation? That was the level at that time, okay? Today, I will tell you it's completely different, okay? Last week, I was Zooming with Japanese mediators. I was Zooming with representatives from the Korean Commercial Arbitration Board. There is so much interest now in mediation. I could show you more slides, but I just want to take 2 examples, okay, with the time that I have. And I want to take the examples of India and China, okay? Now, India is huge, okay? India is made up of 1.3 billion people. Brazil, you are 200 million, but can you imagine India, 1.3 billion? But they've been struggling with the dispute resolution scene for a long time. You know, I have many Indian friends who are mediators, and they tell me it's so difficult. I have a friend who did a mediation. She said the parties were in court for 18 years, okay? And they settled in a day, and they were so relieved. So for India, it's not just dispute resolution, but it's also access to justice. And that's so in many countries. Okay, so what's in this for India? Well, India had this problem, but you know, when the convention happened, we were talking with the Indian delegates and say, look, will you sign? And they say, no, it's going to take time. We are interested, we are keen, but it's going to take time. But you know, we told you the convention was signed on 7th of August. 1 week before that, now we know Prime Minister Modi held a cabinet meeting, and he said India will sign. Okay. Now that was marvelous, but he not only said that, he said India would amend its laws to ensure that mediation would be used in many. So very good for my Indian friends, my Indian mediator friends. And you know, in his address, do you know what he spoke about? He spoke about mediation. Okay. And he talked about, okay, compulsory pre-litigation mediation. That is what is happening in India now, okay? And I know right now they form a committee, okay? They are in the process of getting into place, putting in place the Mediation Act for India. But that's what the impact the convention has had, and down to the. I tell my Indian mediator friend, look, you know, it will not be 18 years the next time. Okay, this is access to justice. I know many other countries have got this issue, and I hope that mediation can play a role. Okay, second example, China. Can I move to the next slide? Yes, China is also 1.3 billion people. Okay, and the Chinese are very interested in mediation. Look at the left bottom photo. That is a photo with the China's Chief Justice Zhou Qiang. Okay, he was in Singapore in October 2018. We met up with him, and he told us personally China was committed to mediation. If you look at that photo right on the left, that's a memorandum of understanding which I signed with my counterpart in Beijing to do Belt and Road disputes. Okay, and we have now done mediation training in China, and there is so much interest. So I will tell you the latest news, which is this morning, just this morning, I signed an MOU with the Shenzhen Court of International Arbitration. We now have a protocol in place where if there is a mediated settlement agreement conducted under the auspices of the Singapore International Mediation Centre, that is now enforceable in China without having to start Chinese proceedings. They will take it, convert it into an arbitral award, and that's enforceable. This is the first in the world, to my knowledge, okay? That kind of arrangement. So you find that this is what's happening all over the world. Mediation has gained traction and it's taken off. And it will affect people's lives, for me. Okay, the two parties, the two Indian parties who had that case, it was so relieved. For me, that is justice for them. So this, to me, the convention has had a phenomenal impact on the growth of mediation, and we've seen it on the ground. Okay, I'm going to move on to my second point, which is the increasing use, okay, of hybrid processes in ADR. And here, may I just move on to my next slide? Okay, so the Singapore International Mediation Centre, we work closely with SIAC, which is the Singapore International Arbitration Centre. Some of you may know of SIAC.
Mm-hmm.
We did this before the convention, all right? 5 years ago, we have this protocol. It's a one-stop process where if you are concerned about enforceability, then you come to SIAC, the Arbitration Centre. Your case is registered, you file your initial papers, and an arbitrator is appointed. And then the case is stayed. Okay, by agreement, the case is stayed for a maximum period of 8 weeks. And the case is sent over to SIMC. We're just really next door. And we appoint a mediator who's a separate person from the arbitrator, and we mediate the case, okay, professionally. We have a panel of 70 mediators from 14 jurisdictions all over the world. They're not just Singaporean mediators. Paul's on a panel. We've got mediators from all over the world. We try to pick the best. And you can pick your own mediator if you want to. So it's very flexible. But with this process, we've had close to 75–80% success rate. Okay. So if the case is settled, then it goes back to SIAC, to the tribunal, and then they will register, they will convert the settlement agreement into an arbitral award, which is enforceable in 160 countries under the New York Convention. So that's what we did to try and address the issue of enforceability. And if the case is not settled, then of course it goes back to arbitration, okay, in the usual manner. So this is a genuine process, and we found that it has actually been very popular with parties, okay. So if you are a Brazilian party now today and you've got a dispute with someone in China and you want to do a mediation with us, we welcome you, okay. You will find that this is easy because you can do it in Brazil, you can do it in Singapore, you can do it online. We are flexible. As Gloria said, the whole process is flexible. You can have two mediators, you can have a Brazilian mediator, you can have a Chinese mediator or Singapore mediator, your choice. But that's what's happening in the world now. So for me, this is the trend, okay? The use of hybrid processes, met up, but in the end, what's best for the client, what fits the case, what gets it done quickly. Which comes to my third point, which is a message which I give to young lawyers, okay? Because a lot of young lawyers say, look, what's the future of the law? And I know that many of you out there are young lawyers. And for me, it has been 38 years in the practice, okay? I started off as a litigator, and then I moved on to being an arbitrator, and I started mediating simultaneously, you know, for 20 odd years. But, you know, for clients and parties, and I think, again, Michele will attest to this, they don't see us as litigators or arbitrators or mediators, all right? They just want to get their problem solved. They just Business people are tired of long drawn out battles, court battles or arbitration hearings.
Definitely.
We just want to get it solved. Yeah. And this is the message we get whenever we go down and meet companies and businesses. So my message to young lawyers is this, okay? Our role has changed, all right? In the old days, you just want to be a Perry Mason or whatever great lawyer on TV. But today, I think, appreciate the fact that the landscape has changed and people want you to be a problem solver. I see us as that today, okay? And if we can equip ourselves with the skills, the different skill sets, I think you will have an advantage when a client comes to you next. And how do you represent a client? I mean, if you're a litigator, how do you represent a client at a mediation if you don't know anything about mediation? Or how do you appear in arbitration? How do you advise a client about arbitration if you don't know about the process? So my advice is please pick up the skills and offer that suite of services. And when a problem comes, don't look at it just from one angle, but how do you design a whole dispute resolution process which helps the party? And that's where we'll make our mark. So on that note, thank you very much for being a part of this. I'm happy to take questions. But for me, you know, Brazil, you've given so much to the world. I didn't mention your coffee. You're the largest exporter. And I think Brazil deserves mediation. Okay, it will be good for your people. It will be good for businesses. And I would encourage you, of course, you know, to be a signatory. And if you need anything, we're here to support. So on that note, thank you, Jair. Back to you.
You're very welcome, George. Thank you very much for bringing such an invaluable piece of advice to not only to our young lawyers, but also to all of us. I don't know if I'm right or not, and thank you for being a fan of Brazilian music. I think, Daniel, that we need, as a token of appreciation, offer to our foreign friends as Paul, George, and Gloria, maybe a CD or something. I do from Tom Jobim, for instance. It will be a pleasure because, of course, the music is something that Brazil has, which is even better than coffee, right? And nowadays we are needing badly to be appreciated, other than politics and so on and so forth, for obvious reasons. But anyways, my friends, I just thank you very much, George. I really think that we are having with Gloria and now with you really a great perspectives on this Singapore Convention. And since we have George and John and Paul here, again, just to make a parallel with the Beatles, let me bring John Lennon here. And he said that life is what goes on with us while we are busy doing other plans, right? So maybe, and just maybe, when I look at, and this is a question, when I look at the Singapore Convention and its meaning for the legal realm, I feel that maybe we haven't been able yet to understand what is coming with it. For instance, when you mention that it enhances a lot the credibility of and the enforcement and the adhesion of the parties to the mediated agreement, you are also saying in the international setting, George, that, for instance, agribusiness agreements that might be financially secured, since they all usually involve commodities, they will become more valuable as bonds in the financial market. If people get convinced, if stakeholders get convinced that it's more credible, that they will be. So credibility, trust, confidence is a very important in the economic market as a whole, and most importantly in the financial markets. So what I would like to ask you, for instance, this conversibility of, which is an automatic conversibility of the mediation agreement to an arbitration award, as you just brought up to us, it's simply amazing if you look, because you're just changing, transforming the very nature of an agreement by like this, you know. So again, what you said is very, very important. It is not about the arbitration team, Liverpool arbitration team against Flamengo mediation team. So there's no competition. As you said, what really matters here is how efficiently every single method would end up solving the problem. So what I would like to ask you is that, do you think that for the general market, for the economy as a whole, especially in times of recession, in which the dark shades of recession are coming over us, right? Do you think that having the convention not only signed but ratified might have impacts, I mean concrete impacts, as the confidence over papers, over, I mean, there's commodities papers that end up being, I mean, end up having banking value. Do you think that this might bring some attraction to our economy again, put some movement into it, or not?
Okay, so I know this is a tough time for everyone, but we also know that with what's going on, there are going to be a lot of disputes arising from COVID-19. In fact, in Singapore, we term it a tsunami of disputes. People who cannot pay their rent, people who had contracts which are stalled, construction matters, you know, who's going to deal with all that? And the type of dispute we have now has got a different characteristic, because many of these disputes have happened not through the fault of one party. It's just the circumstances. So for me, the message today is this: as a society, okay, how do you want to deal with these disputes? Because if everybody fights and asserts that all their rights and you're entitled to do that, you're going to get people going bankrupt, you're going to get people going down, financially strapped, okay? As a society, if you can think of ways to manage those disputes so that people can survive, there's a bit more understanding, there's more compassion, I think we all come out of this better as societies. And I think mediation can play a big role now. It is actually, at this point of time, for me, the preferred mode of dispute resolution. Okay, because it's quick, it's cheap, it's effective, and it gets people to start talking from the heart, talk through your problems, find a way, try and understand, and clear it quickly so that you can move on and do your business. For me, all of us mediators, if you can give that message to people, I think that'll be wonderful. We all will come out of this stronger and better.
Thanks, George. Thanks for your answer. And I don't know what about you, but I can't wait to listen to Paul. That will bring some substantial comments on the functioning, on the very functioning of the convention. Are you ready to go on? Is it okay? I mean, the audio thing, yeah. Everything's fine.
Yeah.
Okay.
So far the audio is good. Subject to the builders who are doing a roof job on the apartment building, and you have to mediate with them in order to get some time. But anyway, first, bom dia, saudações de Miami, a todos, which means, for those non-Portuguese speakers, good day, greetings from Miami, which my friends from Latin America particularly like to say is a very beautiful city with nice beaches, good shopping, and is conveniently located right next to us. So I want to greet everyone. I want to thank the CBMA, especially Jair, Daniel, and Gustavo, for inviting me to join our illustrious panel here. I'm going to quickly glide over quite a few subjects, and you know, it'll be an overflight more than anything with the time that I have. Just to add a little bit to what George and Gloria had mentioned about the countries that have signed the convention, yes, Brazil's main trading partners, US, China, South Korea, and up and coming India in the trade. Well, also the Middle East, almost all the major players in the Middle East have signed this, and Brazil does an incredible amount of business in the Middle East. And not only that, within the Middle East, you have countries that don't like each other, like Saudi Arabia, Qatar, and Israel, all signing it. But Brazil does business with all of them. So as far as being a good cementing mechanism, I think the convention can be helpful there. Now, there were a few things. Also, I have one slide, which I might ask Danielle to throw up there, which outlines what I'll be talking about. First, the convention doesn't affect the mediation process itself. Some people wonder, well, if we sign this convention, is it going to tell us how to mediate? You know, certain mediation's good, certain ones no good under this convention? No, not at all. The convention does not tell anyone how to mediate. The convention recognizes through the UNCITRAL working group with all the countries that George mentioned participating, that there are many different cultural styles and negotiation styles that are embraced in mediation around the world. So the convention doesn't dictate how to do it, and it doesn't really dictate how not to do it. The only thing it does do, it has one article which lists grounds under which the convention would not be enforced in a convention country if the mediation were on a subject that were in that country not legally mediatable or against public policy, I think as Gloria mentioned. Several others like that, incapacity of the parties. Somebody was 3 years old and had their uncle scrawl for them, things like that. And also one which is failure to disclose relationships. So one of the grounds for refusing to enforce the convention, but that doesn't affect the mediation itself. The disclosure would occur before the mediation. In other words, I'm the mediator, and I didn't disclose that my cousin works in the same company as one of the parties. That could be grounds to refuse enforcement of a settlement agreement if it were found by the enforcing court that that type of relationship, if disclosed, would have prevented the mediation going forward with me as mediator. But that doesn't affect the process once you're inside. Once you're mediating, you're free. And that's something important to understand. Next is greater flexibility of the Singapore Convention on Mediation compared with the New York Convention on Arbitration. The New York Convention is the UN Convention on Enforcement, Recognition and Enforcement of Foreign Arbitral Awards, which was created in 1958. That is the one that Brazil ratified, as had been mentioned earlier, in 2002. And with that ratification, arbitration in Brazil took off like a rocket. And because with that convention, arbitral awards that were rendered in one country that was party to the convention could be enforced in any other country that were party to the convention, subject to a few exceptions, but it gave cross-border enforcement to arbitral awards. And so people started thinking this would help international arbitration, and it certainly did. In Brazil, it took off like crazy. And mediation, people say the Singapore Convention is the New York Convention of Mediation, in the sense that it makes cross-border enforcement of mediated settlement agreements in the commercial sphere possible. It is, and it isn't. It is in a good sense, and it isn't in a good sense. It is in a good sense because it does provide the cross-border enforcement in countries that have ratified. You mentioned, and it isn't because it's not as complicated as the New York Convention. It's more simple to implement and more flexible, and I'm going to explain why in a couple of words. First, under the New York Convention for arbitration, in order for an arbitral award to be enforced in another country, another convention country that had ratified the New York Convention also, the award has to be recognized, which is usually a formalized legal process that takes a lot of time. And some countries even require still, in a term of art called ex equator, that the country in which the award was rendered formally recognize it and stamp it, which takes some time. Sometimes it has to go to the highest court in that country. It has to go back up the chain there. Then it gets sent down to the other country to recognize. The Singapore Convention requires no such thing. The Singapore Convention only requires the settlement agreement was mediated as opposed to directly negotiated. And that this settlement agreement was mediated, and it can be proven without showing the settlement agreement to keep things confidential. So you can, how can you prove it in the country where you want to have it enforced? You can have the mediator write a letter saying, I mediated a dispute between Company A of Brazil and Company B of France, and they reached a settlement agreement, period. Signed, Paul. Or if the mediator doesn't want to do that, they can have the institution write a letter saying, the CBMA administered a mediation, international mediation. The convention itself actually doesn't require that, but it allows countries to make a reservation requiring that. And so what happened was many countries have made this reservation. And so the scope of the New York Convention is wide, but it is still somewhat limited, where the Singapore Convention doesn't have anything like that. You can mediate an agreement. Say George and Michele, their companies have a dispute. They have an agreement to mediate. They get Jair to mediate it, and they decide to go to Antarctica on a trip, and they sign it there. Then George wants to make sure that Michele's company lives up to the agreement, and they've been dragging their feet. They can go to any country that has ratified the convention and try and get it enforced there if Michele's company has property there or assets. It doesn't matter that the convention itself was signed or entered into in the South Pole. There's the New York Convention. You would have to have a convention country, at least most countries have taken that reservation to the treaty to say so. Now, things in common, similar to the New York Convention, the parties seeking enforcement of the settlement agreement under the Singapore Mediation Convention can go to the courts of any Singapore Convention country to enforce it. Now, in Brazil, this brings me to my next topic, the possible implementation route in Brazil. Well, for a while after Brazil ratified the New York Convention, that sounded nice, but it took quite a while to get good implementation. It used to have to be implemented through the STF, which is the Brazilian Supreme Constitutional Court, which has 10 or 11, I think it is, justices, not that many. And they deal with all kinds of constitutional questions, and they have a backlog of something like 100,000 cases. They have a big backlog. So I knew one of the code ministers, and I asked him at one point, have you ever had to ratify a foreign arbitral award during that period? He said, no, I never saw one. So at that point, it was going slow. Then in 2005, Brazil made a constitutional amendment and transferred all arbitration-related matters to another Supreme Court. It's the Superior Court of Justice, which is the highest court in Brazil for all non-constitutional matters. That court has something like 30 judges. They have a lot more justices. They have several that are very pro-arbitration. And everything changed with that, in my opinion, in terms of getting foreign arbitral awards recognized in Brazil. And Brazil has been very pro enforcement of foreign arbitral awards. So this is called the STJ, Superior Tribunal de Justiça. So that, to me, that makes, I mean, they might not like hearing this and might increase their workload, but they have 30 justices. That would be a reasonable route to consider to implement the convention in Brazil. Every country, the convention allows every country to figure out their own way to implement it in their country through their court system or administrative system. And so some countries like China, they were threatening not to sign the convention. I met one of the people there and they said, we can't. I said, why wouldn't you sign? I met them in June and they said, well, because we don't know how we're going to implement it. And I was with a US federal judge at a Congress in San Francisco at the time. So I said, I brought the judge over. I said, has the US figured it out? And the judge says, no, we have no idea. So the idea being, it's better to sign it now, and then before the country ratifies it, then they can work and develop a way how it's going to be implemented in their country. But it's not necessary to have everything worked out before you sign it, before a country signs it. Okay, I'll come to the next item, item 4, if we can scroll down a little bit, Danielle.
I will, just a second.
Jair, whoever has the control.
Yes, it's with me. I'm
Okay.
sorry, I'm not good at these things. Just a second,
Okay.
I will scroll it down in a while. Okay, here you have it. Is it okay like this?
Yeah, only 2 convention reservations available. Reservations mean exceptions. It's a treaty language. It means, okay, say Brazil says, sign it, but it doesn't apply to Curitiba or Porto Alegre, but the rest of the country has to abide by the treaty. Or it only applies to certain kind of agreements, but not others, certain mediated agreements, but not others. Or, you know, people say Latin America is run a lot by management by exception. So there could be exceptions, but the law of treaties, and there is such a thing, usually provide that treaties contain in their own texts the only reservations that are allowed. And the New York Convention allows 2, and the Singapore Convention allows 2 other ones. And the 2 that the convention allows, in this case, is it's not applicable to settlement agreements entered into a state party or its instrumentalities, like autarkia in Brazil. So if Brazil were to sign or ratify the treaty, you can take the reservation at signature or at ratification. Brazil could say, okay, we will sign it, and it's okay for all private commercial settlement agreements, but not ones that involve a parte estatal, state party, or parte autarquia. That if possible, they could do that or not. And the other reservation I call B is for the convention to apply in the state ratifying it, but only to parties to a settlement agreement which have previously agreed to that effect. So in other words, they would put in their settlement agreement that this settlement agreement shall be governed by the Singapore Convention. So so far in the process that George and Gloria so well described, only Saudi Arabia and Belarus have adopted Reservation A, which is basically the one that it doesn't apply to state parties. And Iran has adopted both A and B. I remember we were at the table, we were watching in the audience when they were signing the convention, and the Iranian, most of the president of the country or the foreign minister, usually one of them, would come up to the table and sign and bow, say thank you. Everybody would clap and leave. But the Iranian delegates spent quite a lot of time poring over it. So I leaned over and whispered to my wife, Professor Serpo, who was also a delegate. I said, I think they're going to make at least 1 reservation. They wound up making two reservations. So it won't apply to state instrumentalities in Iran, as far as Iran is concerned, that are parties to a settlement agreement, Iranian state instrumentalities, that is. And also that the parties have to previously provide that in their settlement agreement or elsewhere that the convention will apply. Okay, challenges, we're winding down. The COVID-19 is an obvious challenge for everything, and it's diverted the attention of many governments from pursuing this convention, even paying attention to it. which is one reason we're doing this seminar today. I think it's going to be recorded, and we may be able to present it to the right people at the right time in Brazil. And time will tell, but more events like this, I think, will be helpful. And then there's another challenge I call the rarer cases. The rarer cases where, and sometimes you get these in cultural property cases. I've been involved in cultural property mediation summits. For those of you who remember, it's like the woman in gold, the painting that was expropriated by the Nazis, and the rightful owner's family tried to get it back, and they went to court, and then they finally went to arbitration, etc. So in that case, instead of money, the family wasn't interested in money. They were interested in getting that particular painting, The Woman in Gold by Gustav Klimt, back into the family. So in that case, that kind of case, the party, say instead of arbitrating it, the parties that tried to mediate it internationally, and the Austrian government said, okay, we'll give it back, and then they wound up not doing it or dragging their feet, then the other party would have to try and enforce that. If the property itself is not in the country where the party wants to enforce the convention, it's obviously going to be difficult. And so nothing is perfect. But a lot of the commercial, I would say 90-something% of the commercial transactions we're talking about are not about specific unique property, but more about money or fungible, changeable property. And the last thing I'll close with, and also help to lead in with from Michele, is the proactive benefits of the convention, which were referred to earlier. I think I used to be in-house counsel like Michele is now. I was almost 20 years international corporate counsel for Latin America, Russia, Canada, and I also handled things in Europe. And I could say from that, mostly for large multinational IT companies, information technology companies, more businesses would be willing to contract for mediation and use it, put mediation clauses in their international contracts if they knew and were confident that there's a cross-border settlement agreement that wouldn't be slow and expensive and defeat the whole purpose of mediation in the first place. So I think giving it power is really important, like with arbitration. And in fact, to back this up, the International Mediation Institute conducted a survey in 2017, which showed that 80% of international company representatives think the same way. As I said, this did happen with the New York Convention for International Arbitration, but our next speaker, Michele, will address this with more focus on Brazil and business, and I look forward to hearing her. Muito obrigado.
Well, my dear friend Paul, so nice to hear. It's a pity that we don't have much time, but as you said, we will probably have some more events as this one. Let me just warn our speakers that we do have already a lot of questions. I'll just mention three people from the audience that just posed very interesting questions. Beatriz Assef, Thais Dourado, Luis Cláudio Duarte. My dear friends, we will respond to your questions in a while, just after Michele's speech, right? Very interesting points that were raised up by this friends of ours. So, but what I would like, Paul, to ask you is that when you mentioned the implementation route for Brazil, I know that we are still far from this point because we didn't even begin discussing the convention and so on and so forth. But do you think that it would somehow go through the same pathway? Could you please just give us a little more perspective on that we already had with the STJ, and legally, do you think that how it, or I mean, maybe this would have to be under the competence of some ordinary courts, let's say federal courts in Brazil? How do you see, I mean, considering your experience as either a mediator and a ex-house counselor for companies in Brazil?
Thank you. Yeah, I think as a mediator and an arbitrator, I've arbitrated plenty of cases, and I've also mediated Brazilian international cases, disputes, and things in the commercial world. think the STJ, I mean, there's got to be one court at the top that decides everything. And then you could have from there, lower courts could implement so that, you know, the regional federal tribunals could implement. But if the decision were to be somehow or whatever, then there needs to be a route. And it to me seems to be the most logical route. But I think every country needs to develop their own path. I know that a study was started by a very well-known Brazilian whom we all probably know here. And she came to the conclusion first that the Singapore Convention did not conflict in any way with Brazilian domestic law. And I think she, you know, if you have a study that's more detailed than what I, as a foreign personage, would provide, to make recommendations on the best implementation route, I think that would be a worthwhile study.
Great, great. But the mere fact that mediation agreements, international mediation agreements, would not be any more subject only to the ordinary foreclosure procedure that we have right now, this would be priceless. Don't you think so? I mean, for our business community.
Well, that would be terrible because, you know, case backlog in Brazil. Brazil has a population of what, 215, 20 million, and has, I think, 115 million cases in the backlog in the system. So if you put it in a ordinary contract, you know, maybe your great grandchildren will be able to enforce it. That's what the convention is good for, among other things. It's mentioned is speed and getting to the top of the ladder, the top of the waiting list. You know, that's extremely important.
Well, maybe next time we can get a justice of the STJ with us, just to help us, if not for other reasons.
Yeah, there are a couple that would be there's a couple that we know that would be very good and speak very well to them.
Well, let's try to do that. Okay, thanks, Paul. Unfortunately, it's so nice. Personally, I'm a little confused here because the speeches, they are so interesting, and there's so much for us to draw off of each one of them. But Michele, this is your turn. We are eagerly waiting for your speech too, because you will bring a more practical perspective on this whole thing. So thanks for being here with us again, and we are here to listen.
Thank you, Jair. Thank you, everyone. Good morning and good evening for our friends in Singapore. Thanks again for CBMA for inviting me to join this webinar, this first international webinar. For me, it's an honor and a pleasure to participate in these discussions. I have, of course, the difficult task to be the last one to speak after, you know, so many bright colleagues, but I will do my best, you know, to give a practical overview, and especially based on the Brazilian framework, the legal framework, and also the practical examples that I can try to bring for our discussion. I will not have any slides. I know that we are a little behind time, so I will try to not repeat what my colleagues have already said, but I would like to focus also on the current scenario that we are living. And I've been following the CBMA webinars, and I think that it's a great initiative to try not only spread the knowledge, but change the culture. George said one thing that, you know, I really know down here, that we have to change the role of the lawyer, you know, and this is critical at this moment. So I would like to point out that based on the challenging times that we are living, we have to focus on that. And the Singapore Convention, although has not been signed by Brazil, I think this would accelerate the process, also having the UNSTRAL stamp to change this culture. Because in Brazil, we still have the litigation culture, but we are changing that. And I will give some examples of that. Okay, so as we have already mentioned, not only me, but also Paul, Brazil has not signed the terms of the convention yet. And we are terrible on ratifying conventions, okay? If we take the example of the Convention of New York, it took more than almost 50 years. So let's not wait for that to start using and spreading the mediation, not only domestically, but also internationally. In Brazil, actually, mediation is considered a public policy since 2010. We have the resolution 125 of the National Council of Justice, Conselho Nacional de Justiça, that states that mediation is a relevant part of Brazilian public policy to solve disputes and one of its priorities. So our National Council of Justice expressly encouraged the use of mediation in Brazil. And in 2015, we enacted the law of mediation, and also the Code of Civil Procedure that also mentions mediation in several articles, including pre-mediation prior to the filing of the defense. So this is our legal framework nowadays. So we have very solid scenario for mediation, especially domestic. So I do see that the Singapore Convention would bring more effective, considering that the agreement would be enforceable as an award. So would bring even more legal certainty. So I think it's a great achievement for the international community. But one thing that I would like to point out that usually when we reach an agreement through mediation, it's very seldom that it is subject to challenges, at least according to my experience. And this is one of the benefits of the mediation. And actually, this is one of the reasons why inside Shell, we encourage mediation for certain types of cases, because a solution tends to be more sustainable in a long-term future. And actually, since the parties are working together to get that solution, we see that the mediation will be more successful in a long-term relationship. And in the energy sector, just Shell nowadays is not only an oil and gas company, as also other former IOCs. We are investing a lot in the transition of the energy. So in the energy sector, it's very common that we have the same partners for different projects, and also the same partners in different jurisdictions. So the mediation is usually a very fruitful and successful solution if we think that we want to preserve our relationships with those partners. And even if not only regarding that project in particular, or that contract that's subject to certain dispute, but if you want to sustain the relationship in a long term and related to different contracts, different jurisdictions. So, for example, if we think now an example of the oil and gas industry here in Brazil, the concession contract takes 27 years generally and can be postponed as well. So if we think that we have also contracts related to that contract, I'm not sure. Can you see me?
Not anymore, Michele. Now it's okay. Thank you. Yeah.
Okay. Sorry, I missed the video here for a while. So if you think like a concession contract that we have 27 years of relationship with the partner, also, or maybe with other third parties that provide services regarding that contract, we always think about preserve the relationships, and the mediation focus on that. I will not repeat all the advantages that Gloria mentioned, but the confidentiality is something that is very important for us, because it would prevent a reputational risk that in our industry. and if you have also shares negotiating in the market, it does represent a lot of risks, having a litigation or a very high dispute, is in the news. So this is something very, very important for us. also, what I think that is very important, especially considering the moment that we are living right now, thinking outside the box. You know, I think this is what we need now, and what the mediation brings us. Having the mediator to try to facilitate a negotiation between the parties, this is very helpful to get more options. And sometimes those options are not limited to the scope of that contract. As I mentioned, sometimes you have more than one contract regarding that party or that relationship. So thinking outside the box is really important for us. And now I think there is a more relevant issue when we are talking about COVID, coronavirus crisis, and we know that we are going to have a lot of cases going on to the judiciary. Our judiciary in Brazil has already stated that don't come to us. We are not ready for this kind of dispute. Please sit down and try to negotiate. And having a mediator in this time of crisis, I think would facilitate have an agreement. It is already going on. I have a friend that said that the webinar was going to take place today and said, oh, I saw the CBMA's webinar. I wish I could attend, but I have a session on mediation. And I said, okay, so this is a good reason. Don't worry. I know that you will not attend, but this is for a good reason. So it's already happened. So I do believe that for domestic mediation, you have a solid legal framework in Brazil. And for international mediation as well, in the beginning, we'll have the agreement, force of a contract. So it would be enforceable act. The benefit of the Singapore Convention International in this scenario is to have enforceability as an award. Of course, it's very relevant, would be very important. And considering that more than 20 countries that have already ratified, and among them some that Brazil has very trading important relationships, this would be very good to have Brazil ratifying it as soon as possible. But I strongly recommend us not to wait for that to change our culture. I think we in-house and outside councils, we have the role to already change this culture of the litigation here in Brazil. And sometimes, and I want to share this with you, I face more difficulties to try to, when drafting an agreement and trying to include a mediation clause in a domestic contract than in an international contract. Some weeks before the beginning of the pandemic and the lockdown, I was negotiating a contract with a potential partner of the energy sector, and I wanted to include the mediation clause. And it was very difficult to try to convince the other party about that. First, the party only agreed if there was the judicial mediation, and we did not agree with that. So there was like 2 or 3 rounds of negotiation until the party eventually agreed with institutional mediation in the draft of the contract. So sometimes it's harder to convince the party in a domestic contract to include the mediation clause than an international country. Sorry. And this is the reason why I think we have to change the culture, and it's already changing, but there is a long way to go, in my opinion. And one thing is just addressing already one of the questions, because I don't like the judicial mediation in principle, because this is a mandatory mediation according to the Civil Procedure Code in Brazil. And addressing one of the questions, I'm not sure, I think it was Beatriz that raised it. So usually I prefer not to include mandatory mediations when I'm drafting a mediation clause, because it's against the principle. Usually I say that mediation is almost like therapy, you know, to work, you have to want to do that. Otherwise it will not work. But if, you know, the parties want like a mandatory mediation, what I would recommend is to try to fix a deadline to have a conclusion of the mediation. Otherwise, it would be only time consumption. We do not know if the other party will be in the same willing the agreement as you want to. So that's the reason why I do not usually recommend mandatory mediation in the contracts. I think it's, it's against the principles of mediations and against the principles of the parties want to have and wants to reach the agreement. And about changing the culture as well, I think until very recently in Brazil, we would only see mediation as an appropriate type of resolution of conflicts regarding family matters or neighborhood. And this is something that we have already changed in the Singapore Convention. I think ratifies that when we're talking about commercial disputes, international commercial disputes. So I think the Convention of Singapore, it's very important for this mindset changing that we need so hard right now. And I know, for example, in the CBMA webinars that we have had since the beginning of the pandemic, we have discussing, I think in almost all of them, the need of the changing the role of the lawyer. Sometimes winning the case is not having an award in our favor or having a decision in our favor. Before joining Shell in 2017, I worked for private practice for 16 years. And I could realize this change of mindset working very closely to the business. Winning the case does not mean that you're doing the best thing for your business. And I think Gloria and George mentioned that we need to focus on the business, focus on the results. And in terms like, in times like the one that we are living right now, when we have the need to preserve relationships, preserve commercial relationships, the mediation, I think, is the better solution for long-term relationships. And I congratulate again CBMA with the initiative to try not only spreading knowledge, as Daniel mentioned in the beginning of this webinar, but especially to work on this changing of culture. It's very hard, to change the culture, but I think the COVID-19 scenario is accelerating that, and to give solutions for the parties and the best solutions. I invite all the lawyers in-house and outside counsels to think about that when thinking about the strategy of the case in the early stages of the case, when proposing something for the client, think about the business, think about the time that will take that case, because this is ultimately what the client wants and what the client looks for. So I think the Singapore Convention it comes because it's going to be effective in September, but comes in a very challenging period for all of us, but it helps us with this changing of mindset as well. Although Brazil has not ratified or even signed it yet, I think it ratifies the desire of changing of culture. I think that's it in a nutshell.
Well, Michele, that's not it. That's a lot. Thank you very much. You brought really great information, especially for our audience. And just let me thank you very much. It was wonderful, Michele. Just let me ask you this. Afterwards, I will assign the questions that we are receiving from the audience according to the subject of each one's speech, right? But right now, Michele, I do have this. I'm eager to know that since you are responsible for the Latin America and Caribbean area in terms of international business and everything, and you have a solid experience in arbitration, litigation, and so forth, can you give us briefly an example of how any of your past cases would possibly benefit from a would-be ratification of the convention in Brazil? Let's just imagine and make believe that that at that time the convention already existed and was in force in Brazil through our own mechanisms. Can you just for the audience to understand really concretely how this might benefit? Thanks.
Okay, I cannot speak by heart now about any agreement that we reached in the recent past that was not compliant with by any of the parties. As I said, I think when the parties reach an agreement through mediation, the parties are willing actually to comply with the agreement because they actually built the agreement together, you know, together with the mediator, but together. So I think that it's easier to have the parties complying with agreement, which is very different from an award or from a decision, you know, because for an award or a decision, a party is actually losing. So it's very common on the other side, and then I can give examples that a party will try to annul the award or try to avoid the enforcement of the award in their jurisdiction. And this is the reason why the Convention of New York was so important for that. And then making a comparison, as Paul mentioned, since the Singapore Convention has the aspiration to be for mediation, as the New York Convention is for arbitration, I think, of course, that will bring certainty, legal certainty for agreements that are celebrated regarding different jurisdictions, different parties, international commercial agreements. But in my experience, what I would say is that when the parties reach an agreement through mediation, is very rare that they want to try to annul the agreement because they worked very hard and they worked together to reach the agreement. That I wanted to call the attention. Okay.
Thanks, Michele. And other than that, you didn't mention, of course, out of modesty, but they would know better before messing with Michele, right? Right? They would not want to have you on their knees, you know, because she's a terrific lawyer and litigator, right? So that's it. Now, I'm joking, but I'm serious. Well, my dear friends, thank you very much. Let's go right away to the questions. George.
Jay, just beforehand, I'd like to make a standing invitation for Gloria and George. Whenever you want to come here in Rio, feel that CBMA is your home. I don't need to say that to Paul and Michele because it's already their home. So they already know CBMA and they're already there. So, but George and Gloria, please, whenever you want to come, we have some excellent international events from mediation through arbitration, and every year we do that in March and in August. So you have a standing invitation, just let me know. And you also have a standing invitation to publish and to make part of our editorial board of the Brazilian Journal of Alternative Dispute Resolution, which Jair is the president of international boards, and I'm the editor-in-chief. So you have an invitation for that. We're publishing a lot about all ADR subjects, and mediation and Singapore Convention is a big topic right now. So you have a same invitation for everything. Feel at home here in Rio and at CBMA, okay? And I extend this invitation to all your friends in Singapore. Thanks a lot.
Thanks, Daniel.
Thank you, Daniel. Thank you, Daniel. And we offer that same invitation to all of you to come to Singapore. And Paul has been to Singapore, but the rest of you, I'm sure you know, anytime.
Recommend Singapore. It's a beautiful place. It's very modern, efficient, safe, which you can't take those things for granted anymore. It also, in my humble opinion, the world's best airport by far.
You see?
Counts since you got to fly there. It's a long walk from And it has a very diverse multi-ethnic culture also, which is also very, very interesting. So I had a great experience. I was there in 1973 for the first time when I was in another life doing I was doing something else. And Singapore was great then, but now it's advanced. It's in the 23rd century already, you know, where's
that's for sure.
Back there.
It's amazing the job that you are doing down there, you know. I mean, up there, I would say that the Singaporeans, they are the Brazilians from Asia, but just a good part of Brazilians, right? That's how I like to think about it. But George, my friend, let us begin with you. There's this question. It was asked by Thais Dourado. She's in our audience, and she phrased the question like this: I'm not sure if I gotten it correctly. So will HKIAC recognize a mediation agreement as an arbitral award for the purpose of enforcement in China? How would it work? So this is very interesting indeed. I mean, that situation that you mentioned, that in China they will convert an agreement into an award, and because this just goes around all the complications. China doesn't even need to sign and ratify the convention, and you have enforcement right away. Could you please just give us some light on how this works?
Okay, so maybe I just preface that by saying that, you know, we are all in support of the convention, but we know it's going to take some time for it to become truly effective around the world. Maybe 5 years, maybe 10 years, I don't know. So right now we're still working on mechanisms, different mechanisms to assure parties who come to mediation that their agreement can be enforced in the event that something goes wrong. Okay, so this MOU that I was talking about, Memorandum of Understanding, it's brand new. Okay, I just signed it this morning. It's a matter of principle, but the understanding is that if we have a mediated settlement conducted under the auspices of the Singapore International Mediation Centre, our counterpart in China, okay, in Shenzhen, which is a province in China, and that's the Shenzhen Court of International Arbitration, would recognize that settlement agreement and would register it as an arbitral award. So it's like a court doing it, okay? And once it's converted, then it will be enforceable as an arbitral award in China, within China.
Good, wonderful.
So that's the principle of it. That's the framework.
I see.
The details have not been worked out. We are going to work out the details probably within the next couple of months. And if you tune in, I will give you
that would be great.
Updated information as it comes about. But
yes,
this
please.
is the intent. This is the intent, and I think, you know, it is wonderful because we're all saying we're trying to work together to make sure that this whole dispute resolution environment works for parties.
Great, thank you, and thanks for this allowance. So I'm sure that a lot of people will be much interested on this too. But Gloria, let me just ask you, I know that we already assigned you a question, so if you don't mind, I will add something to it, right? Because I don't know, maybe I'm wrong, right? Paul will correct me if I am, but under the convention, if it is an arbitration award of any form, it is not enforceable, and it couldn't be, of course, because of the 58 New York Convention. So if I'm not wrong about that, don't you think that maybe this trend, and I'm sorry to bringing up some questions because it's a very creative way of going around, I mean, the time, the span of time that will be necessary for the convention to be signed and ratified and everything. But don't you think that this may somehow bring a little vulnerability? Because I know that it was difficult during the convention for you to come up with many different hypotheses and so on. So first, if you could just bring something extra on that. And second, Luis Claudio Duarte, who is in our audience, he is asking, what is the reason for the European Union for not signing the convention, why they didn't do that. And I know as an insider that probably Paul told me that there was a harsh debate about a hypothetical model law, mediation model law, as the arbitration model law that we have, ancestral and so on. So if you just could give us some insight on this, both things, would this going around mechanism somehow vulnerate the convention as it is right now? And second, why the European Union haven't signed the convention and, well, had that position of those guys?
Okay, actually, I look at the different mechanisms for enforcing agreements or awards as different options that users have to choose the option that works well for them. Some disputes, the parties may find arbitration useful or litigation, and in that context, mediations, comes up as a new option with the convention coming about. So I think constructing the convention, and of course George may also add his views. The idea was so that there would not be an overlap in terms of the coverage of what the conventions. There are different conventions covering arbitration, litigation, and now this was the mediation one. So I see the carve out of the arbitral awards as a very cool and neat way, right? In which I think when they were drafting, they were seeking to deconflict. So otherwise there will be confusion, and you may even get litigation over whether it should be coming under this convention or another enforcement mechanism. So I do see that it is actually useful for that clarity as to what the convention applies to. So that was on the first one. And on the other issue of whether the European Union, why they had not signed, my understanding was that I think they have an issue of competence. They have to discuss whether they choose to sign as a block, if there's a consensus and they sign as a block, or whether they can sign as individual states. So I think that is something that will take time for them to work out, but there seems to be some support for the convention, and we hope they'll be able to sort out the issue on competence soon.
Fine, Gloria, just another question related to this one. Was the European Union working on a kind of mediation model law, more or less in the trends of arbitration ancestral model law? Or was this maybe, I know that you're very diplomatic and I don't want you, of course, to bring anything that would touch into sensitive matters, right? But was it a issue when you were discussing the ratification and so on and so forth?
Yeah, maybe George can add on, but I understand that the discussions, I think part of the compromise was that there would be a convention that would be part of the product of the work group, and there would also be a model law, so that countries that actually could not possibly adopt the convention could still have access to a model law which they could also use in their country. So I think that was the compromise that was worked out, and therefore there are two instruments which are put out and for use by different countries depending on their needs and the situation and the framework that they have to work within.
Thanks, Gloria. Very informative. George, would you like to add something before we just jump to Paul?
Yeah, so I think like in a mediation, different parties have different interests. And here we were trying to accommodate the different interests, because there were countries who said, we think the idea of mediation is good, but we're not quite ready. Perhaps mediation is not quite developed. Perhaps they wanted to do something else, have their own laws. So there was this debate over whether we should just have a model law or have a convention. And in the end, and on a snowy day in New York, We all cobbled in the lawyer's room, and we came up with a compromise. And part of that compromise was, let's have both. Okay, a model law as well as the convention, so that those who felt they were ready could sign the convention. Those who felt you wanted to take a step before that, they could just subscribe to the model law first. So we thought this was a perfect mediated settlement.
That's it, man.
Accommodates everyone, yeah, and in time there'll be more and more signatories and ratifications.
Sure. And I'm sure that a great mediator as yourself put your finger in this issue too. No, but you don't need to confirm or not, right? This is just my.
I think it was a big no. It was really a big team effort.
I think so. Yeah.
And everybody in the end came together. That was the wonderful part. You know, there were times during the sessions that we thought, oh, it's not going to work, but we all just kept going. It's resilience. It's just like going through this pandemic. You know, we just got to tell ourselves we'll get through this. Yeah. And as I said, right. I'm sure Brazil will. Yeah.
Thank you, my friend. Thanks. We are badly needing your encouragement. Thank you very much. It's very sensitive of you. Thank you. Paul, my friend, let me ask you this. We have Beatriz Assef. She asked, is mandatory mediation positive? And I would add a model law. You mentioned before during your speech that, and George said this, every single country will, eventually come up with its own version of the ratification act, right? But having a model law that is somehow patronized or brought up by an European Union or whatever, how much this would consume, parties. And so my question is just making Beatriz's question a little bit broader. And is being mandatory in mediation a positive thing? Michele also said something about it, but Paul, please feel free to make your comments on that and everything that goes along with this.
Okay, thank you. Well, first, going back to the EU for just a mini second, I think one thing that might be interesting, a positive thing that might come out of the UK leaving the EU is that they may be more free to sign the convention. It can be diverted away from the COVID and all the other problems they got. But the EU has hung together as a block, as far as I know. They had their own mediation directive, which really hasn't taken that much internal traction within the EU, and I think that may also play a role in the proposal to have a model law instead. Now coming to mandatory mediation, it depends on what you mean. In some, it can mean different things to different people. If for example, mandatory mediation in many countries, Argentina next door, for example, means before you can proceed in court with your case, you have to try mediation, you know. Brazil, the Brazilian mediation law didn't go that far. They rejected that, and the Brazilian mediation law only says it's mandatory if there's a clause that provides for it, and then you have to try it at least for a little while. Commercial context, though, you know, first, because most Brazilian judicial mediations would not fall under the Singapore Convention because they come out of the judicial system, which is excluded. Most of them are not international anyway, so they would not fall there. But the international commercial cases, more of those are regulated by contracts, as Michele was saying. My experience in corporate counsel was I would put in multi-tier contracts. Usually, a lot of the times. First, the parties try negotiation at the executive level. If that doesn't work for a defined time period, then they go to the next step, which is mediation. If that doesn't produce within a certain time period, then that can either go to arbitration or court, public court, whichever they have agreed on. So it's not mandatory mediation in the commercial sense that they have to go through the whole process. And it's not even, it's something they contractually agree to in the case. So it's not mandatory on them, except that they already agreed to do it. And if they the company sign an agreement to that effect, but that there's a time period. And I've noticed that in the case of some Brazilian ADR centers, they don't provide for a time period in their rules. I just finished an article which should be coming out in the Brazilian journal Temas de MEDIAÇÃO e Arbitragem. Well, they promised it in July. I don't know, we'll see. But this article touches on this issue, which is basically for a clause, standard clause. It could be one that the institution provides to anybody who wants to use it, or the lawyers of the company, like Michele, draft individually for their company to provide for mediation. But if you don't put a time period, then you never know when the mediation ends or not. You don't know whether you're allowed to start the arbitration or not. So great, but it has to be extremely well drafted. Otherwise, it backfires like a boomerang. Then you wind up in court, which is what you're trying to prevent. But you need to have very good drafting. But with very good drafting, these kind of, we call in Portuguese, cláusula escalonada, or English step clause, can be effective. But that's not completely mandatory. It's mandatory if the company agreed for it to be mandatory. But it's the attempt that's mandatory, not the result. You got to try it for 30 days, 40 days, whatever you agree, 5 days, whatever you go. And then if it doesn't work, then either of the parties can say, okay, it didn't work in the time. Then I can go to arbitration or court, depending on what the next step is. So that would be my answer about that. And then my other comment, which is tangentially related, the COVID-19. Is reinforcing what George and Gloria had said, especially. You know, now things are just upside down now. So it worked before, doesn't work now. So in-person meetings don't work now. Seminar like this, in-person doesn't work now. Everything video. But now a lot of companies don't have money like they used to sustain litigation, or if they lose, to be forced to pay the judgment on it. Instead, besides more disputes and ADR cases, more of what Brazilians call recuperação judicial, which is a kind of bank. You're going to get more bankruptcy, more countries are going to wonder. Those companies, whether they're claimants, they may not have the money to pay the lawyer fees to push the case. Brazil has huge backlogs of cases, as I said, 100-something million. And time, and they don't have the time because by the time their case comes, they might be done, or the defendant might be done. So doesn't it make more sense to negotiate and mediate some kind of a settlement while people are alive and have a little bit of financial viability to come to something that makes common sense? Thank you.
Thanks, Paul. Just on that note about a time clause, either for step clauses or arbitration. Recently, there was an article that came up in India because in Supreme Court they are discussing very much about the pros and cons on time clauses, especially in arbitration. So I was thinking if the other way around would not be a little bit more effective. For instance, if you just have very well drafted time clauses on arbitration, once they get to the deadline and they cannot get to an agreement, maybe then we could get back. Why not? Why mediation has to come first?
Right. It doesn't have to come first. In fact, there are some very interesting models where the mediation can either be done in parallel, or another model, which I find at least intellectually attractive, although I've never seen it done, is that you actually do especially a simpler case with a single arbitrator. You case first, the arbitrator arbitrates it, writes an award, sticks the award in his desk drawer, and doesn't produce this award, and then says to the parties, okay, let's try and negotiate something. And you have so much time, you agree on the time period, and if they don't get a result, then he pulls out the award. And that way he hasn't gotten access to confidential information in caucus from either party before they decide the case. So that's another, there are a lot of options. Mediation is extremely
I mean,
so you can make a clause for that instead of the normal sequence, which I said. When you negotiate, this is a time to think of these creative options.
Yeah, that's the reason why it's nice to have experimented people on our webinars, because we all went through the shenanigans and everything. I mean, in the good sense of the word, but time clauses would be worth a webinar by itself. But anyways, Michele, let me thank you, Paul. Thank you very much. So nice, so enlightening what you've been bringing up. Michele, just let me ask you this. would you resort to this, I mean, again, hypothetically, this MOU and go with a convertible mediation agreement to an arbitration award in order to warrant the compliance of something? The thing, I mean, in other words, as a business, as someone responsible for battling the daily battles of business, right? Do you think that this kind of model might thrive in South America, in Latin America, and in the Caribbean, or not?
I think it works. I think it would work for sure. But as we have already mentioned here, I don't think that, you know, a mediation prior to arbitration is necessary. I would like, I like what Paul said and you said about, you know, we can have mediation at any time, and we have to think out of the box, as I said. And I think the purpose of this webinar is inviting everyone to think about outside the box and try to figure out the best option to use mediation, and try to use, you know, the tactics of mediation or even negotiation to have the best solution for the client and for the business. There is no, what I would like to say is that there's no guideline that would be strict. We have to think considering the case that we have in our table, considering also the parties involved in the demand, but we always have to think on the solution and what we want from that relationship. And this is something that mediation helps us a lot. When sometimes the parties are struggling, a mediator will help. So I would like to close this invitation to everyone to think outside the box and try not to only follow guidelines. That's it.
Wonderful. Thanks, Michele. And this is people, they are already bringing up more questions. And this one is specifically for Gloria. And Luis Lopez, right, from our audience, he asks, Gloria Lim mentioned the importance of creating awareness. I would like to hear her on whether, in her view, it is more important to focus on awareness of lawyers or businessmen, right? So, and Gloria, before you go for this one, let me, Michele, ask you, because since you've been first working at a very prestigious Brazilian and of course associated with a worldwide law firm, right? And now you are with there goes and so on. You've been talking to a lot of I mean, CEOs and clients and businessmen and so on and so forth. Would you please just give us your impression on who is more flexible, I mean, and more willing to think outside the box? Are businessmen more I mean, more likely to go through this pathway, or lawyers are tending to become more flexible? So, and then please, if Gloria could just go on and just respond to the question, I would appreciate that. Please, Michele.
Sure. I think both need to think outside the box, but usually, for example, it's easier for me to convince my clients, you know, inside the company, the business, that we should go to mediation or try to reach an agreement, than sometimes to convince the other lawyer that going to court or going to arbitration is not a good solution. You know, I think for me, it's easier nowadays to convince my business partners than sometimes the lawyer of the other party.
Maybe, so, Michele, if we just put the lawyers aside and keep the business people in, it would be better, right? Just let's close all the law schools. I'm joking, of course.
That's true.
No, I'm not serious, because, you know, otherwise probably the Brazilian Bar Association will come over me and so on. I'll have 6 lawyers, 5 lawyers here, but you know, it's better not to take chances. Gloria, would you please, did you finish, Michele? Would you like to add something here?
No, I think that's it. You know, I think, for example, the culture of the negotiation is very present in businessmen and businesswomen who are always working with negotiation, actually. So that's why sometimes it's even harder to try to avoid the litigation culture in the mindset of the lawyers. So I would say that it's easier for me to discuss that in-house with my business players and clients than with my colleagues. And I say that by experience.
Fine. On the other hand, just to give some contrast here, I've remembered that George said, listen, you have to look, and you said that too, you have to look at the situation and then decide with what conflict resolution method you will go. And this is just to say that contrary to some assumptions that we have today, there's nothing wrong with being a litigator. Right. Sometimes you have some strategic advantages by on going through litigation that are simply you cannot replace them with any other one. So many situations and so on and so forth. Thanks, Michele. Gloria, could you please give us some perspective on that? So, what is more important now, businessmen, lawyers?
I think it's a very interesting question, and I would actually reframe it to say the awareness needs to be with decision makers, people who have the decision-making power to decide on where how the dispute should be resolved, and also people who have an influence over the decision makers. And that's where I think the lawyer has a big role. The in-house counsel play many roles within companies. And they have an important role in deciding on the dispute resolution solutioning strategy that the company takes. So I agree with Michele totally that I think both the lawyers and the business people need to have an awareness. And I think on the lawyers' part, the interesting thing is the lawyers also, it's about back to the idea about changing the role of the lawyer to solutioning. Helping the client find a means of getting the result that they are looking for, and I think there's a lot of scope for lawyers. And in fact, I understand there's one strand of work that's developing, which is mediation advocacy, getting lawyers to themselves, learn about mediation and also advise their clients accordingly, where they think that mediation is a useful means of resolving the dispute. Mm-hmm. So I hope that addresses the question.
Oh, that's for sure, Gloria. But just let me ask you something before we jump to Paul here. You played that piano back there. Can you play afterwards something for us? I'm joking. Maybe some other time, right?
Another time.
but I like to see that you're a very sensitive person and a musician. Great. So this is your just can we have our guest George before Paul? George, please go ahead. Go ahead. I'm sorry, I guess that my.
Okay, I just wanted to add on to what Gloria said, because for me, I mean, I'm a lawyer too. For me, it's.
I'm sorry about that. You're a nice person, but then no, about being a lawyer. I'm joking.
It's probably better to include the lawyers in the process. And that's what we've been trying to do in Singapore. Show the lawyers that, look, hey, you can pick up mediation skills, you can use it, you can become mediation advocates, and at some point you can be a mediator as well. Because clients are going to go to the lawyers for advice. And for me, like in a mediation, I welcome the lawyers to come, because look, if you just get the clients to come and you want them to make a decision, before they decide whether to sign, they're just going to go back to their lawyer. So I'd rather have a lawyer included in the process and be part of it and be a stakeholder. And I think that it's a slower process, but for me, inclusiveness is better. And that's, to be fair to our lawyers in Singapore, in the beginning, of course, there's not a lot of awareness. People are resistant to a certain extent. But right now, I think the legal profession in Singapore as a whole has embraced mediation as a part of the scene. And it's what a role you can play in it. And if people can see that, and that's also in their interest, then all the better. And I always remind the lawyers, we all took an oath when we became lawyers, which was to act in the best interest of our clients.
You're right. You're right.
It is
And we're
ethical-
talking about we're talking about different things here. You're right.
Yeah.
Mhm.
But I think that is the way to go in the end.
Sure. That's true. And this is very important. Your remark is very important because we're talking about different times, different stages, different languages. To the client, as Michele said, you usually have to speak a certain language. They must, they are sensitive to a different level, different scale of arguments. And so Gloria and Michele, they are totally correct about that. But the point that you made right now, George, is really important because sometimes when we talk about mediation, lawyers might feel a little bit lost with no role to play, and they must be welcome, and they must be not really. Yes, they know a lot of things. Of course, we are all lawyers, but I mean, maybe we could add some value on their roles by introducing a little bit more of this psychological, cultural code that might end up in more solutions, in more agreements, and ultimately more money, right, at the end of the day. Of course, that we're not only focused on money, right? But anyways, Paul, please, would you please bring up your...
I was just going to add to what had been said. When I in my days as corporate counsel, we tried to practice a term we coined preventive law. Preventive law, the idea of preventive law was to counsel the client and make agreements and arrangements that would try and prevent problems from happening. Because once they started, it's always more complicated to solve them, whether by mediation or any other method. So we would try and do that, and that was to some extent the idea of putting mediation clauses in contracts, because once the dispute starts, then a lot depends on who feels they have the power as to whether they're going to want to mediate or not. Where they're signing a contract, that's not known. Most of the time, you don't know what kind of disputes are even going to come up. You signed the contract 5 years before. So I usually try and counsel the clients to do that. On the other hand, also, when I'm a mediator, and I have lawyers in the room, I had one, actually it was a Brazilian case. There's one Brazilian case where one side brought 5 or 6 lawyers and the other side brought one. And there was an Argentinian one where one side, because they had insurance and reinsurance, they brought like 6 lawyers, and the Argentinian side just brought the business manager. So I try and lay out in the beginning as an introduction when I do mediate that the lawyers have a positive role to play, even though the process itself is not a legal process. It's a assisted negotiation process. It's legal. In other words, the lawyers shouldn't be running it for the most part. But they have things that are important. I mean, there's, even though mediation and are more interest-based than rights-based, legal rights-based, there are certain areas where legal rights need to be identified and the lawyer can help. And also, if they reach a settlement agreement, I as mediator, I won't draw that up for them. I might do a bullet point memo of what they've agreed on and then ask the attorneys to negotiate that.
Right.
Just that they're not driving the car, they're in the car, but they're part of the.
But you know what, Paul? What you just said reminded me of the story that this is just for us to getting to the end of this webinar. So I would just allow me to bring up the story, which is very interesting indeed. So it's said that God and the devil had a quarrel, and they decided to solve the problem through mediation, right? But the thing is that, so they settled a specific time for do that and everything. And so it was a certain Wednesday at 9:30, and everybody was there. I mean, the devil was there waiting for God, and 6, 7, 20 lawyers with the devil, one of each specialty, and they were ready with beautiful suits and everything, and so forth, so on and so forth. And 9:40, God didn't appear. So what happened? So at a certain point, God is coming. He's a little, breathing hard and everything. And the devil said, well, listen, God, what happened? You didn't bring any lawyer with you? And he said, well, I'm sorry, it was impossible to find one in heaven. Right. So meanwhile, the devil had that whole, team of lawyers. Of course, that I'm joking. And lawyers are fine. We are all lawyers, right? And but it's just seriously now, it's very important to have them on board, right? And sometimes they look suspiciously at mediation because not now, but law schools. So far as 10 years ago, 5 years ago, they didn't talk about mediation at all, specifically in Brazil, not in the United States. I remember the first time I've heard about arbitration, mediation, and so on, active listening, was when Robert Fisher came up with getting to yes. This was back in the 80s. I'm sorry, I was not only alive at that time, but kicking too. So I'm really old. But anyways, but in Brazil, this was not possible. My dear friends, Daniel, I would like, maybe we could just wrap up this because people are hungry, not only of knowledge, they need also, they need some bread too, right? Anyways, so I would just beginning with Gloria, if you just could make your final line and just say goodbye to people and everything. I'm sure that all of you would kindly answer any other question that the audience has. You just, my dear friends from the audience, you just send the questions to us at CBMA, right? You have the email there, and we will send them to the specific speaker. If they have time, of course, they are very busy and everything, but I'm sure that they will be more than happy to help. Gloria, would you like to come up with your final comments, and then we will wrap up at the same order that we began with Daniel.
Thank you for having me here. I've really enjoyed the discussion today. I hope this is a continuing discussion, that we will continue to talk about mediation. And I just want to encourage the participants to continue to be interested in this. And I look forward to seeing you at another summit webinar, hopefully another CBMA webinar.
Thanks for being with us. George, would you like to add something to us?
I really enjoyed tonight as well, or this morning as well. But I remember now not to talk about Liverpool Football Club. But one thing that is significant was that you all said, you could actually sign the convention first and ratify later. Mm-hmm. That is actually quite significant, because the signing simply demonstrates your support, your willingness to go. Mm-hmm. And maybe that's the way to go for Brazil. I think that's probably your better place to decide how to go forward. But if you could get this done first, I think it'd be wonderful, because Brazil is already a signatory to the New York Convention, right, Paul?
Yeah. 2002.
So I mean, to me, for the businessman, you should just give the business people an option. And it's not difficult. If you've already got in place legislation to support the New York Convention, it's not difficult to have something similar for mediation. So I will leave this with you all, but I really hope from the bottom of my heart that Brazil will be a signatory very soon. Thank you.
So do we.
Thanks, George. And thank you, and I hope to play some soccer with you. I mean, maybe next year, right? Okay. Thank you very much for being with us. Paul, please, my friend, your final comments.
Maybe it would be futebol virtual, Jair. Virtual soccer. I want to thank everyone. I want to thank the CBMA, Jair and Danielle especially, and my co-panelists, George and Gloria, for your great patience late in Singapore, and Michele, especially, for taking time out of her busy day as the corporate counsel, which I know what that's like. You don't look for clients, they look for you. So it's not, it's very different. I would add, is a unique country in all Latin America. It's the only Portuguese-speaking country with a very different cultural history and all. But it is worth noting that quite a few Latin American countries have already signed on to the Convention. Chile, Colombia, Ecuador, Paraguay, Uruguay, Venezuela. So Many of the countries around have done that. And maybe Brazil should sign because Argentina hasn't. So they'd like to do the opposite. So like a football match, you know. Thank everyone again, and we'll see each other again sometime soon, I hope.
Thank you, Paul. Thank you. And let me just say that if it was not for Paul, we wouldn't have this team of experts together here. So you contributed a lot, both CBMA is in great depth to you, because, you know, as usual, since 1970 something, even though I'm older than you, my friend, but you know, you've been for a long time helping Brazil, right? And you have I know that you have some personal reasons to do that. We will not get into that, right? You have a wonderful Brazilian wife who's also a great expert on mediation. She has written the best book on mediation that we have in Brazil. And so we will not we will be insisting on having her with us next time, right? So thank you, Paul, thank you wholeheartedly. If it was not for you, this would not have happened. My dear friend Michele, your final remarks.
Thank you, everyone, for this opportunity. We have been saying here about changing the culture and, you know, exchanging experience in a webinar like this. I think it's a great opportunity for changing the culture, getting the best part of every culture as well. So it was for me an opportunity of knowledge, and I learned a lot for your experience, George, Gloria, and Paul. It was also a great opportunity to meet Paul again. We have worked together in a law firm here in Brazil. He is almost a carioca, as you mentioned. And as you said, Jair, I think in Brazil we are working a lot, but we have some recent developments. You mentioned about having some disciplines at the universities. I didn't have the opportunity to have like dispute resolution, alternative dispute resolution methods when I was at the university, only when I was studying for my master's degree. But now, and it was an initiative that the Bar Association in Brazil had a great, actually put a lot of effort on. There is, it's a mandatory discipline in all universities. So I think this is a great achievement, and this is part of this change of mindset. So I just want to, since you raised that, I just wanted to conclude with also that we are, I know that it's a long way to go, but I think we are on the track. Okay.
Thank you very much, Michele. It was very important to have someone from the oil and gas industry here, and we also thank, I mean, your friend Claudio, right? Claudio, is this his name? That help us to have you here, right? And Shell. So thank you very much, because we are stealing some precious hours of your work day. So we have also to be grateful to Shell here. Go ahead.
It was Gabriel Costa.
Yes, Gabriel Costa. I'm sorry.
He's a great guy.
Yes, he's one of the heads of the legal sector of the Shell. So please send him our best regards. So he helped us a lot too. And thanks, Michele. Thanks. We know how busy you are. Right? Yeah, thank you. Daniel, you're very welcome. Daniel, is up to you to wrap up the seminar, my dear Vice President. Go on.
On behalf of Gustavo Schmidt, our dear President, and we're really grateful for having you here. I've learned a lot, and I know all the audience has also. They are thanking you through our YouTube channel. We had people from Brazil, but we also had people from Singapore watching it, which is great news. I know it's late there, late at night, and thanks a lot. I really appreciate everything I heard. You know, I'm trying to memorize here, and I have some paper ideas already, and I'm gonna discuss with Jair. And you know, as an academic, I like to write everything I hear and to research, to go deeper. And one thing that I was thinking about is that such as the New York Convention and also the Singapore Convention was written in 5 original languages. And in the New York Convention, we had a difference between the French version and the English version. That, you know, the interpretation of the courts was different. May or must, reject. So in the Article 5 of New York Convention, I hope that doesn't happen in the Singapore Convention, you know, because it's the original language, so you can't go back and see the original language that it was made, because they are original, you know, from the first time. And that's I think that's a characteristic really peculiar of this kind of conventions. I think the Singapore Convention was originally made in English, Arabic, Chinese, as I read, 5 different languages, right? Just like the New York Convention. So
the official languages, the official. But Brazil, they actually, I think the STJ, they don't use the New York Convention that much. That's always been an issue. They use the Brazilian arbitration law more. That's most arbitralistas in the audience would probably say so. They don't rely on the New York Convention as other countries do, even though Brazil did.
Okay, but Daniel, just let me put a note on this. The Brazilian version of the convention was made by Nazaré Serpa, the official, and Carla Araújo, right? And so it's worthwhile to mention that, because it is very well translated, a great version that we have, and you can find it online, right? So thanks to Nazaré and Carla, we have this Brazilian version so well knitted, so well done, right?
It's on the International Mediation Institute website is where it can, it's the www.imimediation.org is the, they have the Portuguese there.
That's it.
But anyway, just to wrap it up, thanks. I hope we see each other soon in our journal, our ADR journal. Of course, you're invited. I will send you guys the formal invitation. George and Gloria, who's already part of it. Michele, it's open for you too. If you want to contribute, be my guest. And thanks, Jair, for hosting it. You know, it was really great. You are really great. So thanks a lot, everyone, and see you soon. And Luis has the doors open for you always.
Thank you very much, my friend. So with that, we will end the session. Thank you very much. Again, Gloria, Michele, Paul, and Daniel. I'll leave the meeting, but the ending the session is upon you, my dear friend Daniel. Bye, my friends. Thanks.
Bye-bye. My pleasure.
Ciao.